Question number 1, can I shoot someone who is on my property? Florida Statute 776.013, subsection 2, subsection A. The person against whom the defensive force was used or threatened was in the process of unlawfully and forcibly entering, or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle. Or if that person had removed or was attempting to remove another against a person's will from the dwelling, residence, or occupied vehicle. According to this statute, the Florida Castle Doctrine law would only apply to a person's dwelling, residence, or occupied vehicle. Therefore, you are never allowed to use or threaten the use of deadly force simply because someone is standing on your property. Question number 2, does the Castle Doctrine apply if I'm staying at an Airbnb? Florida Statute 776.013, subsection 5, subsection B. Residence means a dwelling in which a person resides either temporarily or permanently, or is visiting as an invited guest. It doesn't matter if you're inside of your home or an Airbnb. If a person is entering or attempting to enter unlawfully and by force, you have a right to defend yourself as long as the use of deadly force is a reasonable response. Question 3, how does the Castle Doctrine law differ from the stand your ground law? First, let me explain what most people refer to as the stand your ground law is more accurately referred to as the Justified Use of Force statute. This is Florida Statute 776.012, subsection 2. This statute outlines the requirements a person must meet before using or threatening the use of deadly force. These requirements are a reasonable belief of imminent death, a reasonable belief of great bodily harm, a reasonable belief of the imminent commission of a forcible felony. The use of deadly force has to be necessary. You must be in a place where you have a right to be. You cannot be engaged in criminal activity. While Florida's Justified Use of Force statute applies to the use of force in any location that the victim has a legal right to be, the Castle Doctrine requires the victim to be located inside of a dwelling, residence, or occupied vehicle before the use of force is permitted. Question number 4, does the Castle Doctrine give me the right to use deadly force in a friend's or relative's home? Yes, the Castle Doctrine extends to any dwelling, residence, or occupied vehicle where you have the right to be. It simply doesn't matter. If you are inside of a dwelling, residence, or occupied vehicle that you have a right to be in, you have the exact same rights to use or threaten the use of deadly force under the Castle Doctrine as your friend or family member. Question number 5, can the Castle Doctrine and duty to retreat coexist? Yes, the Castle Doctrine law outlines specific requirements that must be met before an individual has no duty to retreat. Needless to say, if these requirements have not been met, the individual is required to retreat. Question number 6, how can I lose protection under the Castle Doctrine law? There are 4 ways that the presumptions granted under the Castle Doctrine law can be eliminated. First is if the person who entered your dwelling, residence, or occupied vehicle has a legal right to be there. This is found in Florida Statute 776.013, subsection 3, subsection A. Second is if the person being removed is a child or grandchild and the person removing the child or grandchild has lawful custody. This is found in Florida Statute 776.031, subsection 3, subsection B. Third, if the person who uses or threatens to use deadly force is engaged in criminal activity. This is found in Florida Statute 776.013, subsection 3, subsection C. Fourth, if the person against whom the defensive force was used was a law enforcement officer. Florida Statute 776.013, subsection 3, subsection D. To learn more about how each of these presumptions can be removed, go back to the very beginning of this training to learn more. Question number 7, does the Castle Doctrine extend to an RV, motorhome, trailer, or hotel room? Yes. Florida Statute 776.013, subsection 3 and subsection 4 both use the term dwelling to define a location where a person has the right to defend themselves. Subsection 5A gives us a definition of dwelling. Dwelling means a building or conveyance of any kind. including any attached porch, whether the building or conveyance is temporary or permanent, mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Question number 8, does the castle doctrine allow me to stop someone from stealing or breaking into my vehicle? So we talked about this in a previous video, but the answer is no. Just because somebody is trying to steal your stuff does not mean that you have a legal right to use or threaten the use of deadly force. You can, of course, try to stop the bad guy with physical force. You can dial 911. You can turn on all the lights outside to try to scare the bad guy. But running outside with a gun in your hand is definitely the wrong decision. Question number 9, what if the burglar doesn't have a weapon? If the burglar enters my house unlawfully and by force, it doesn't matter if they have a weapon. According to Florida Statute 776.013, you have 2 massive presumptions under this law. The first presumption is that you have a right to stand your ground. A person who is in a dwelling or residence in which the person has a right to be has no duty to retreat and has the right to stand his or her ground and use or threaten the use of a firearm. The second presumption is that you have a right to believe the attacker is planning to commit an unlawful act involving force or violence, as outlined in Florida Statute 776.013, subsection 4. A person who unlawfully and by force enters or attempts to enter a person's dwelling, residence, or occupied vehicle is presumed to be doing so with the intent to commit an unlawful act involving force or violence. So the bottom line is, it really doesn't matter if the bad guy has a weapon. If the bad guy entered unlawfully and by force, and your use of deadly force is a reasonable response, then we are allowed to do whatever we need to do to keep ourselves and our family members safe from this evil person. Question number 10, can I open my front door with a gun in my hand? You cannot open the door with a gun in your hand. As many of you know, a few months ago, I received a phone call from a criminal defense attorney here in Tampa, and he asked me if I would be willing to be an expert witness for a case that was going to trial that next week. So I said, sure, I think that'd be really cool. So tell me about the case and let's see if we can negotiate a deal here. He said that his client was inside of his home and he got a really loud bang on the front door. His client was scared. He thought something bad was happening. So he grabbed an AK-47, walked to the front door and opened it, assuming it was a bad guy. Except it wasn't a bad guy, it was a FedEx driver. So this homeowner decided to set the AK-47 down on a table and sign for his package. And the FedEx driver left. To this man's surprise, the police arrived at his home a few moments later, and he was arrested for brandishing the firearm. Brandishing a firearm means displaying a firearm in a rude, careless, angry, or threatening manner, not necessary in self-defense. As this attorney was telling me this, I said, okay, so what exactly are you wanting from me? He said, well, I want you to stand in front of the jury, and we want you to tell the jury that it is very natural for a gun owner to open the door with a gun in their hand. Are you for real? I said, that is not what normal gun owners do. If your client was so afraid of the person knocking on the door, why did he open the door? If you're really that afraid, if somebody really thinks that somebody's trying to kick in the door, wouldn't the natural thing be to barricade yourself in a secure area with the gun pointed at the door, get on the phone with 911, and wait for the police to arrive? Why would you open the door? I say it's just not logical. I turned down this opportunity because I'm not going to lie, and I think what this man did by opening the door with a gun in his hand was very, very stupid. It is illegal. And we have to be much smarter than that. It's okay to have a gun in your waistband when you're opening the door, but it should never be in your hands unless you have a legal right to use or threaten the use of deadly force in that instance.